Hello, and welcome to the Three Questions podcast, where we dive deep into the world of wealth management and connect you with industry experts. I'm your host, Wayne Baxter, Senior Executive Manager at One Capital Management. Now, if you're planning on including firearms in your estate plan, stay tuned. Why is that? Well, our topic today is the 3 questions to ask before setting up a gun trust. Thank you for taking time to check us out. And if you enjoy this episode of the 3 Questions podcast, please consider liking this video and subscribing to our podcast and YouTube channels. On this episode of the podcast, we're exploring a niche but crucial tool in U.S. estate planning. It's called gun trusts. In the U.S., firearm ownership is widespread, and National Firearm Act regulated items require rigorous compliance. Failing to take the necessary steps to comply with varying state laws can lead to legal penalties, asset forfeiture, or family disputes. Joining us to review the 3 questions to ask before setting up a gun trust is my friend, Supancic. He is a Woodland Hills, California-based attorney with the Law Collaborative. Ty specializes in the area of family law, estate planning, and gun trusts, with his focus on collaborative solutions and helping clients navigate complex asset transfer. Ty, great to see you. Thank you for making time for the podcast today.
Likewise, Wayne. Thanks for having me on.
Now, Ty and I recently attended a Provisors Affinity Group meeting in Woodland Hills, California. And out of the blue, I don't even remember what the context was. Ty brings up the topic of gun trusts. And I almost hurried to my desk, on my neck, looking around going, gun trusts? Now, as somebody originally from Canada, where gun laws, as everybody knows in Canada, are far stricter, the country is basically disarmed hundreds of years ago, the concept of a gun trust is, pardon the pun, foreign. Now, that said, here in the U.S., there are over 500 NFA items registered annually, and we have evolving estate laws. So an understanding gun trust isn't just about firearms, it's about safeguarding your assets and peace of mind. So before we get to our 3 questions, Ty, I think we should start off with the basics. So I got a lot of folks listening in from Canada or watching from Canada and all over the United States. So first of all, what is the NFA? And what is an example of an NFA regulated item?
Sure, thank you. So the National Firearms Act of 1934 was enacted in response to the rise of organized crime and gangs that came into power during the Prohibition. The NFA was essentially a tax on machine guns, short barrel rifles, sound suppressors, aka silencers, and other dangerous weapons, or all other weapons. It required that any individual who wanted to possess such an item get permission from their local head of law enforcement and pay a $200 tax for them, which in 1934 was the equivalent of about $5,000 today.
That'd be a princely sum back in the day.
Exactly. So this acted as a bar against possession for most normal folks because A, they couldn't afford the tax, and second, they were unlikely to receive permission from their local police chief or sheriff. And never closed
unless there was some graft.
Right.
Yeah.
You're right. It probably didn't stop any gangster. Well, they're obtaining them illegally anyway. So a loophole that they never closed was that entities, like a security company, like Brinks, for instance, entities don't need to get permission. They only need to pay the tax. And the tax was never adjusted for inflation. So entities like companies or trusts don't need permission from the head of law enforcement in their jurisdiction. Gun trusts were developed as a means for people to obtain NFA-controlled items in jurisdictions where it's legal to do so. If you want a silencer so you can hunt or shoot targets without blowing out your eardrums, you get a gun trust, you pay the feds $200, and you're good to go. For the most part, California is not one of those jurisdictions. They serve a different purpose here. Here, gun trusts are designed to convey firearms legally and safely from the grantor to their heirs. Nothing illegal can go into a trust. A gun trust will not fix or save a forbidden item. But if an item later becomes illegal to transfer, a gun trust can maintain that item for the use and enjoyment of future beneficiaries as trust property. Almost every year. I'm sorry, go ahead.
You know what? I didn't mean to cut you off there, Todd, but I just couldn't help but ask, how often does this come up in conversation, like with a client? Are you talking about, is this like a one-off, or like over the course of a year when you're discussing a client's estate plan, how often does the topic of gun trust come up?
100% of the time, because it's to omit that question is potentially leave a booby trap for the successor trustee or the heirs, because at least in California, by default, everyone is a prohibited person. Every Californian is prohibited from taking possession of firearms unless they already have a firearm safety card or an FSC, which requires they pass a test that's administered by a licensed instructor and they pay a fee. And the card only lasts for 5 years. Besides that requirement, there are dozens of other reasons people can fall into the prohibited person category, both at the state and the federal level. Things like restraining orders, criminal convictions, hospitalizations, or the use of federally prohibited substances like marijuana. So many of your friends, upstanding citizens, are legally prohibited from possessing firearms or ammunition in the state of California.
So it basically is de rigueur is a requirement to have a gun trust. If you're in any way, shape, or form, highly suggested. If you're sitting with a client and you ask them, "Do you have a gun collection?" It's like that's a starting point of, well, okay, we have
one gun.
A gun.
Yeah, one gun can create an accidental felony.
Well, that's why you're here, Ty. Always, I will say this: we regularly cover estate planning topics here on the podcast, and if we cover a wide range of topics. We recently talked about charitable remainder trust. Tom Caldwell, our friend Tom Caldwell, was recently on talking about charitable remainder trust. So if you want to learn any more estate planning topics, and I'm sure Ty, your episode will always be available. Just go to our website, www.onecapital.com/3questions.php, or you can also go on Spotify or Apple Podcasts, and you'll be able to find all the episodes, all the episodes of the podcast there. So again, today we're discussing the 3 questions to ask before setting up a gun trust. And my guest is Ty Supancic. He's a Woodland Hills, California-based law collaborative. Ty, why don't we get right to our 3 questions? And away we go. Question number 1, very simply, what does a gun trust do?
So a properly written gun trust safely maintains a tricky asset class and provides for their safe and legal conveyance if possible. If conveyance isn't possible because of future change in law, a trust can maintain those items in its possession for the future use and enjoyment of heirs.
Well, okay, this goes back to what we were talking about before, but I'm going to bring it up again just in the context of your response. And that is, as a follow-up, I would ask, do I really need a gun trust? Do I really need one? Is it how stringent is the rules around
that? There are no rules around it. The question is, do you love and care about your heirs? Do you want to safely convey assets that may have considerable value to your heirs? Are you concerned that future changes in the law would prevent the maintenance of that property? Every year, California tries to pass a law that would ban the conveyance and purchase of semi-automatic rifles, even antiques like M1 carbines or M1 Garands, family heirlooms. Will have to go to the smelter unless you've got a gun trust that could maintain those items. Again, California has to change the law, but they try every year.
So what happens, I guess, as a follow-up question on first person context here, what happens if I own guns? And I'll note, I know she's listening in, my better half Susan will say to me, being Canadians, remember, she says to me ask me once in a while, do you think we should buy a gun? And so to that end, what happens if we own guns but don't have a gun trust? And I'll say for the record now, we do not own any guns, right, at this point. Any of the authorities listening in right now, unequivocally don't own any guns yet.
So I won't use you two as an example, but let's say grandma and grandpa have a gun in the closet and grandpa dies. And grandma says, I don't want it anymore to one of her grandkids, take it away. If that kid uses marijuana, if they fall into any one of those numerous prohibited persons classes, she's guilty of a crime. The heir is guilty of a crime. Even access to the house, if the gun is just in a closet and it's not locked up, that constitutes constructive possession. Obviously, the police have to make an arrest. The DA has to decide that the DA wants to prosecute, but constructive possession is a crime as well. So even one gun needs to be properly maintained, just like you'd have a gun safe or a gun lock. It's about storage. It's about safe conveyance. It's about protecting your loved ones.
Okay, so I got a question. How are we hear trusts all the time here in California, obviously. How does a gun trust differ from a standard, good old-fashioned revocable living trust when it comes to owning these firearms? And I guess beyond that, is there any type of multi-generational transfer, process in putting them together?
Sure. So because gun trusts are designed to maintain and convey firearms and shooting accessories like ammunition or suppressors, a lot of the language is specific to that class of property. There are also written restrictions on who can serve as a successor trustee and be a beneficiary. And a normal trust doesn't have any of that restrictive language. Normally, you name the person you want as your successor trustee, you name one or two backups, and there are no restrictions on them serving other than they want to serve. A gun trust, because they could become prohibited persons, has to include a lot of other language.
Interesting.
Also,
how often, Ty, just another thought here. I know this is supposed to be the 3 questions podcast, and this one is turning into the 33 questions podcast. So my apologies for that, but this is just really interesting. As a general rule of thumb, when I meet with clients and we talk about estate planning, not that I'm an attorney, but we obviously encourage our clients to have a trust, an estate plan. And I often tell them, you ought to really review your trust every, say, 2.5 years, maybe meet with your attorney every 2 or 3 years, just to go over the language to make sure that everything is above board. For something like someone who has a gun trust, how frequently would you say we should get together and go back and review it? Is there a frequency that may be more frequently than 3 years, or what's the rule of thumb if you have a client with a gun trust?
So every time that their situation changes significantly, their goals change significantly, or they become aware of a change in the law. I have a mailing list, a private confidential mailing list for all of my past gun trust clients, where I send them updates when I understand that there's a pending change, when something's that might affect their trust. I let them know, hey, this is what's come up. If this affects you, give me a call. So I try to prompt those conversations. But clients in any kind of estate planning, they should always reach out to their estate planners whenever their situation changes, their goals change, or they become aware of a change in the law. They change the exemption on the death tax or something.
Well, it seems similar to what I tell a client. They should come and may always let me know. We try to review with our clients 2 or 3 times a year, but I say whenever there's a major change in your situation, that will potentially change the overall financial plan. So it sounds like you have a sort of similar baseline. Ty Supancic joined us today. He's from Woodland Hills, California-based Law Collaborative, and we're addressing the 3 questions you should ask before setting up a gun trust. So, Ty, we spent quite a bit of time on question number 1 and buried you with several follow-up questions. So let's see if we can make it a little bit easier on question 2 here. Question number 2, what are the downsides of having a gun trust?
Is it okay if I circle back to the end of question number 1 real quick? You asked about multi-generational transfer. Yeah. Well, it's one of the, not always do we have heirs that are interested in our collections, but we may want them maintained. Maybe you've got something that belonged to your great-grandfather or your grandfather. A gun trust is also a way to maintain those trust assets and skip people who aren't interested, or preserve them for people who might become interested in the future. So that's another advantage to it. You might not want to liquidate grandpa's grand, but you may not have kids that are interested in it. You might have a grandkid that would be really interested in it, but once it's been liquidated, it's gone. And so that does provide for that possibility. So downsides, cost. If you're really cost conscious, you may not want to spend the money on getting a gun trust, especially if you've got one gun. It might be worth $200. You don't want to spend money on something that's worth $200. So I think you need to make sure, though, that you do account for its disposal at the end of your life, so that your heirs know what to do. You don't want someone accidentally discharging the firearm when they're going through your things, killing themselves or a loved one or a neighbor because you didn't properly store it. So cost is a concern. Another one, privacy. Gun owners tend to be super private about owning firearms. I got clients that won't admit they own firearms, and then halfway through the process, they say, well, the reality is I got 3 guns. Okay, I'm an attorney. I take your secrets to my grave. No one will ever find out you told me you've got guns. I'm not going to tell anyone you got guns. But some people are concerned about privacy with regards to gun trusts. If you download one on the internet, if you buy one at the gun store, that's not private, that's not confidential. If you're using a lawyer, you shouldn't have to worry about confidentiality or privacy.
So I'm just thinking about, we were talking about reviewing and keeping on top of things. So what sort of ongoing maintenance or cost should gun owners anticipate when they have a gun trust, and can they be minimized? Or or maybe I better put it a different way. What are ways to minimizing these cost burdens?
Think about what it is you really want to accomplish, because one reason that a person might incur fees later on is because they change their goals. Rather than leave their trust property to an heir, they want to leave it to a charitable institution. Okay, that requires rewriting their gun trust now, or amending their gun trust. So if you put enough forethought into it, there shouldn't be any ongoing changes or ongoing expenses. But again, as we said earlier, anytime your circumstances change significantly, your goals change, or the law changes, you should at least check with your attorney or your estate planner and say, hey, this has come up. Do I need to do anything?
Okay, well, we got through question 2 a little bit more quicker than we did question 1. Let's move on to the third and final question today. Again, we're asking the 3 questions you should ask before setting up a gun trust. And we got Ty Supancic joining us here from Woodland Hills, California, and he's with the Law Collaborative. So question number 3, do I have to update my gun trust if I were to move to a different state? So we'll just use the example of, say, from California to Florida would be a good example. Thoughts on that, Ty?
It's always wise to speak with an attorney licensed in your state. My trusts are written to federal guidelines with California-specific clauses. It should work in every state, especially a less restrictive state like Florida. But you want to make sure that you speak with an attorney licensed in your new jurisdiction whenever you move. Any kind of estate planning, you want to check with someone licensed in your new home state.
So are there specific states, though, Ty, that where a gun trust isn't required whatsoever? Or is it in all states that one is required?
Well, for NFA restricted items like short barrel rifles, automatic weapons, sound suppressors, AOWs, those require either a gun trust or permission from your local head of law enforcement. And if you can't afford to, as you suggested earlier, grease their palm, then you're going to need a gun trust. For the conveyance of standard firearms, they're not necessary. I think they're still wise, just like it's, even if you live alone and you don't have grandkids, your gun should still be locked up. You don't know who's going to break into your house. You don't know what guest is going to take the wrong turn when using your restroom. I think it's a safety issue to have them locked up.
Okay, Ty, you've just opened a can of worms. I can't help myself. I told you going to have like 33 questions here today, but I'm really glad to have you with me here. You just brought something up. These are, again, hypothetical, and I probably should have my friend Silva Merchadician on with me because she's a criminal defense attorney, but I'm going to throw this one at you. So hypothetically speaking, I have a gun in my home in California that I don't have any register. I have it registered, but it's not in a gun trust. Somebody breaks into my house, literally breaks into my house, trips over a gun and gets shot. So is it a legal, what's the legal issue? Is it because the person got injured with a gun in my house, or because I don't have it properly registered with the state in a trust?
So interesting. Trusts do not register your firearms. We are very, very careful about not registering firearms when we do a gun trust. So I don't list the items.
So
the vast majority,
we'll assume the gun is registered, but we don't have it set up in a gun trust.
But the vast majority of firearms in California are not registered, Wayne, and it's completely legal. Registration has only been required relatively recently.
Interesting.
Yeah, most guns. So for decades, they did background checks, but that's all they did, Wayne. You would pass the background check and they would even write down what you purchased because you passed a background check. So there was no registration. Only relatively recently, like I bought lots of guns. I'm old. I bought lots of guns that are not registered. Only recently have they actually started keeping track of what was purchased. So most guns aren't registered. But there are negligent storage laws in California. And if your firearm is negligently stored, which means not locked, loaded, anything the DA says is negligent, and someone is injured, you can be prosecuted for violating the negligent storage law.
Even if it was somebody who was criminally breaking into my house to steal my stuff.
If the cause of their injury was your negligent storage, absolutely.
I knew there was a reason why I had you on the podcast. This is good stuff. Okay, so let's say a gun trust holder moves to a more restrictive state, and I guess California would fall into that category. Are there any specific amendments that you would make and like to local laws, or is there any how would you revise that? I don't know, Texas maybe. I'm just
great question. So if you're moving from almost anywhere to California, except Hawaii, where firearm ownership is, I think, basically banned for the most part, California has a whole group of firearms that we've called assault weapons. We've defined them not by what they do, but how they look. Do they have a stock that can be adjusted to fit different sized shooters? Makes it an assault weapon. Does it have a pistol grip? So you're holding your hand like this instead of like this. It's an assault weapon. Can you remove the magazine? It's an assault weapon. I'm dumbing it down.
Couldn't a kitchen knife be called an assault weapon too, by the way?
If you could adjust the handle, yeah.
Out there.
So assault weapons, if you've got them legally in another state, you cannot move them to California. They cannot come here. There was a brief period in California where you could register assault weapons that you had, and once you registered, they became non-transferable. If they're in a gun trust, there's lots of estate law. There's lots of probate law that says changing the beneficiaries or heirs of a trust doesn't constitute a transfer of property. You know, if you have one trustee owning a house and then another trustee steps in for the first trustee, the house hasn't changed ownership. The house is still owned by the trust, right? Mm-hmm. If beneficiaries stay in the house, it doesn't change the ownership of the house. It's still owned by the trust. So those guns could be maintained here, but they can't be moved here.
Interesting. Okay, so with your experience in family, like you're a family law attorney, you do estate planning, obviously. So what's one misconception about gun trusts that owners should debunk before setting one up? I mean, and how do they ensure that it aligns with the overall legacy goals? Like, where do we start here?
Yeah. So a lot of people think that if you have a gun trust, you're a gun nut or you're a gunny. I think if you have loved ones, especially if they don't share your enthusiasm for your firearm or firearms, a gun trust is doing them the same gift as keeping them safely stored, keeping them locked, keeping them from falling into the wrong hands. I think it's the safe and loving thing to do. I mean, there are fishermen in Palau that go out to fish and never come home, because in Palau it's considered bad luck to prepare for a disaster. So you don't bring extra water, you don't bring extra gasoline, and they don't plan, and they never come back from their fishing trip. I think not having a gun trust but owning firearms is like that.
Like me not taking water with me when I went golfing at Moore Park on the weekend. It was 97 degrees outside. Noted, yes. Those who fail to plan to fail, right, Ty, as we like to say. So let's look ahead here. 2025 or beyond. Now, I know it's hard for you to envision how things might change, but we know that federal laws, state laws can evolve, and so is there any proactive steps gun owners should take now with that in mind, that time passes and things change?
Yeah. So countrywide, gun restrictions tend to be relaxing. Gun manufacturers claim they made 15 million guns in 2023. Preliminary reports suggest that Americans bought 15.3 million guns in 2024. Estate planning professionals and people planning for their estate need to keep in mind the likelihood that this conversation should come up and be had. To bury your head in the sand and say, my client lives in a real, liberal area. They probably don't have guns. I'm not going to bring up. I don't want to upset them. I think that's irresponsible. I think it's malpractice. You need to have these conversations with your clients. You need to have these conversations with your family. Honey, I don't want to spend the money on a gun trust, but there's a gun in my desk. When I die, here's what you have to do. And then you probably need to tell someone else, because you might die with your spouse, and someone else needs to not be surprised and find that gun in the number of people who are injured and die from negligent discharge is staggeringly upsetting. You need to prevent that.
I as a child growing up in Bear River, East Nova Scotia, it happened to a classmate of mine in elementary school, or what, I'm trying to remember what grade it was. It was either like grade 6 or grade 7 in that time frame, and it was playing with a gun, and he shot and killed his brother in Canada. It was shocking beyond belief, obviously. And then there's, of course, the hunting ones. We grew up in the country, and people go, I used to say the first day of hunting season in Nova Scotia was kind of the equivalent of Vietnam back in the day. Everybody out hunting at the same time. People, it's horrible. Okay. Ty, we could go on here forever, but I respect your time. You're an attorney. You other things to get to. So I just want to ask like one simple last question. Obviously, I imagine we provoked a lot of conversation with folks listening in today or watching. And so for the folks watching, they can see all your contact information on the screen. We put it there for everybody to see. But if they're listening on, in their car on Apple, Spotify, or however they're listening, and they want to get a hold of you, what is the best way for them to reach you?
Visit my website, thelawcollaborative.com, thelawcollaborative.com. And my email address is Ty, T-Y, at thelawcollaborative.com. That's probably great. I might give my number too, but no one's going to, if they're driving, they're certainly not going to write it down. But they might remember Ty at thelawcollaborative.com.
Well, Ty, I want to thank you. I think I've known you almost as long as I've known anybody since I moved here to California. I really appreciate you coming on the podcast with me. Again, Ty Supancic is a Woodland Hills, California-based attorney with the Law Collaborative. And Ty, thank you so much for joining us today.
Thanks for having me, Wayne. It was awesome.
A lot of fun. It was. I look forward to bringing you the 3 Questions podcast. I hope you find them educational and informative. Please consider liking this video and subscribing to our podcast and YouTube channels. And to receive a notification of when our latest episode has been posted, please click on the notifications bell. Last but not least, to schedule an online Zoom consultation with me to discuss your wealth management needs, please click on the link in the description box below, www.onecapital.com/ Meet with Wayne. Thank you, and we will see you soon.